I am really pleased to introduce today's guest speaker, Emily Clough, who's here to discuss the power of effective personal planning. She says they're much more than just papers. Emily is a managing partner with Clark Wilson LLP and a sought-after voice, particularly for clients with incapacity issues and to protect the rights of vulnerable adults. Emily assists clients in all aspects of estates law, drafting wills and trusts, pre-incapacity planning, administering estates through probate, and litigating contentious disputes. All of which is to say we're in good hands today. And so welcome, Emily, and over to you.
Thanks so much, Lori. As Lori mentioned, I'm a lawyer. I've been working out of downtown Vancouver for quite a while now. I guess about 15 years. I've always practiced my work in law in the area of estates, and that takes me from what many people would call the two sides of it, meaning I help people do their documents to do their planning, meaning a power of attorney, representation agreement, a will, a trust, whatever that may be. And I also help people when things hit the fan, if you will, and when things aren't going well, and when there's a fight, and when there's a worry that the documents aren't valid, maybe that the person wasn't capable, maybe that they were unduly influenced or pressured into making their documents. So in my experience, I've seen this from both sides of it. So I can give you some information about how to try and prevent problems. That's the best thing we can do, is try and prevent problems. And I'll talk about some of that as we go along. So here we go. Haha. So the main topic today is that the power of effective personal planning documents. These personal planning documents are something that all adults can do. A little bit, unfortunately, it's something that changes province by province. So if you or your family member or your loved one is here in British Columbia, it's easy because this is all about British Columbia law. Where it gets a little tricky is when people are switching over provinces. If that's you or if that's someone you know, you can help encourage to say, now that whoever it is here in BC, it's easier and better if you do new documents here in BC. If you've come over thinking, well, I did that in Ontario, I already did that in Alberta, it's easier if you, unfortunately, redo it here in British Columbia. So what do we mean by personal planning? That means making the arrangements for your decisions. And that has two aspects. Who can help you make decisions, whether those decisions are about your money, your finances, or about your health care, your personal care, anything to do with your personal life and decisions. So those documents can help you set out who you want to help you. And the documents, importantly, also set up that there may come a time that you're not able to make decisions for yourself, and you need somebody to make those decisions for you. Those documents set out who is that person, who are those people who can be making decisions on your behalf. It's so important to do these personal planning documents because that helps to make sure that the decisions that are made for you in the future are being made by somebody who you trust and would want to make those decisions for you. It's also so important to do those personal planning documents while you are able. I meet with lots of people all over the spectrum in terms of age, you know, from young people to people in the middle ages like me, to people who are retired, to people who are older adults. And sometimes people will say, oh, I'm too young, I don't need to do those documents. Or sometimes people will say, oh, I don't really have that much. I'm not a wealthy person. I don't need to do those documents. I am here to say everyone should do those documents because we never know what's going to happen to us. We never know. The example that I like to use is you never know if tomorrow you're going to walk out the door and be hit by that bus and have a big tragedy and really wish that you had your documents in place. Because if you don't have those documents in place, it can be a real scramble and real difficulty for those who do want to help you to have that proper legal authority to be able to step in and to help you. So part of what personal planning, these documents can do is help you set out to make sure there's someone in place to help respect your wishes in terms of things like what personal services do you want to receive? Where would you live? Sometimes through doing the work on these documents and then through communicating with your person or persons who you'd like to help you, you can set out what your preferences are. Would you prefer to live at home? Would you prefer to live in a big place or a small place? Would you prefer to have care? Would you prefer to have that care at home where you are, or would you prefer that you can live in a place where you can have that care in that place, whatever that may be? You can protect through these document your wishes in terms of the who. Who is it that's going to be helping you make these decisions or making those decisions for you, to make sure that somebody you trust is put into those positions, someone you trust who will make good decisions on your behalf if you need help with your decisions or if you're ever not able to make decisions. The last bullet on my slide here talks about protecting your wishes in terms about how your estate is distributed after your death. Most people will do that through a will. And I'll have some slides later on that will take us through the big things to think about in terms of a will. When I'm doing this work with clients, as I've done lots and lots of that over the years, I kind of break it down into looking at the documents that we need to protect our wishes while we're alive. So while we're alive, but perhaps we need help, or perhaps we're not able any longer to make our own decisions. Who can make our decisions about our money, our finances, and who can make our decisions about our health care? That's the one set of documents. And then the other set of documents are, one day, you, me, and every human will die unless there's some great medical breakthrough. We're pretty confident that death will come. And so we can plan ahead to say, whenever that day may be, what is it that I want to happen with my stuff? Who do I want to get my stuff? And who would I want to be in charge of my stuff, because they're a trustworthy person who I think would do a good job in dealing with my wishes and getting those fulfilled. I'll get into these all in more detail. But in order for you to best protect your wishes, you must do the thing, which is making the documents. Because I'm involved in lots of cases where we have disputes, where people don't agree. I see it a lot, what happens when people say this, and people say this all the time. Oh, I don't need to do those documents. I've already told my spouse what I want. I've already told my daughter what I want. I've already told my sister what I want, whatever it may be. People think I've already done enough because I've already told people what I want. I'm here to tell you and encourage you and inspire you perhaps to do the next thing, which is to get it onto a piece of paper. It's so much more effective, clear, and easy for people when it's written down on the proper piece of paper. So now we're going to get into a little bit of the details. about what those pieces of paper are called. And I'm going to walk you through what they're called and a couple of the details of each of these documents. But I want to also say this. Don't feel like you need to memorize the names of these documents. Hopefully, you'll be inspired to get some help in making these documents. So lawyers can do that for you, and notaries can do a lot of that too. And if you meet with a lawyer or a notary and say, I want to do my personal planning, I want to make sure there's a written plan in place for if I need help making my decisions and what happens after my death, well, that lawyer or notary is going to know all about the names of these documents and the details of those documents. So I will go through some of those details to help educate you. We all do better the more we're educated about stuff. But also don't feel like you need to memorize all of this, because by going to see a lawyer or a notary, they'll think about you and your situation and what documents you might need. I can see just in the chat, I'm not going to go through all the questions as we go along, but there was a question in here about one of the pieces of paper as well that's available out there. It's called the MOST, Medical Orders of Scope of Treatment. I'll talk about it at the end because that is another piece of paper, so to speak, that's out there. But we'll talk about these three today. The representation agreement, which allows you to put out on a piece of paper who you would like to help you make decisions or make decisions on your behalf about your personal and healthcare decisions. So things like, where do I live? Things like, what kind of healthcare do I get? Who do I interact with? Even down to things like, what do I wear during the day? It's possible somebody may need to help you make those decisions or make those decisions for you. And who would you want to do that? The next document is called a power of attorney. That's a confusing name, and I wish we didn't have that name, but we do. Because some people think, oh, an attorney, that's you, Emily, you're the attorney. As a matter of fact, in Canada, we would call me a lawyer. In America, they tend to call their lawyers attorneys. But an attorney under a power of attorney is just the word to say the person who you've authorized to be in charge. It's not referring to the lawyer or the attorney. And then we'll talk about a will. A will is a document that you can make that allows you to set out who will receive your things, your money, your real estate, your watch, whatever it may be after your death, and who will be in charge. So let's go through a little bit of a detail here in terms of a representation agreement. So a representation agreement lets you appoint who the name we use is the representative who can help you make or make for you your health and personal care decisions. If you make a representation agreement, your representative, so the person who you appoint to make your decisions or help you make decisions, they have duties. They must act honestly. They must act in good faith. They must take care in making decisions. They must act within whatever the document says. So the document might say, you can make any decision that you think is in my best interests. Or the document may say, this is only about this type of decision. This is giving you the authority to help me or make decisions for me about my care home, but nothing else. That's possible. Your representative must consult with whoever it is made the document. I'm saying you, assuming it's you who makes it, but maybe you're here to help somebody else. But whoever is the adult who made the representation agreement, they must be consulted with as far as that might be reasonable to do. And the representative must act based on your beliefs, your values, and always, always in your best interests. Part of why I'm setting out here the duties of a representative is to help you to think about who you would want to appoint. as your representative. And you would want to appoint someone, it can be one person, it can be 5 people, who you think would be able to do these things. You'd want to appoint somebody who can act honestly, who can act in good faith, who can always act in your best interests. I'm going to spend a few minutes here, not a lot of minutes, just on the different types of representation agreements. And the reason I don't want to spend a lot of minutes on this is there's a heck of a lot of details between these 2 types of representation agreements that are possible. And my overall suggestion to you in terms of these documents is to get some assistance. Any lawyer or notary who does this work will be able to tell you which representation agreement you should get, and you can rely on that. But I'll go through these here just so you know that there are options. So there's a Section 7 agreement, which was intended to be there so that adults with some incapacities, maybe with some cognitive impairments, maybe with some decline in their cognitive functioning, will still be able to make a document that respects their dignity so that they can say, this is the person or the people I want to help me make decisions or to make those decisions for me. So there, yeah, Section 7 only has a limited amount of power that they can do. And as I've seen a little bit in the chat here, it is true that sometimes the banks don't love a Section 7 representation agreement. They're more used to a power of attorney document to be used for finances. There is a little bit of a tension between what the law would say. The law says a Section 7 representation agreement should allow somebody to make routine decisions about financial matters. But then what does a bank do? The bank does kind of what they're used to doing, or they may have concerns to say, oh, we want to see this in a power of attorney. Sometimes it can be tricky. So that was a little bit about a Section 7 agreement. It's there. It's not as common as the other type, but a Section 7 agreement is there for those adults who do have some type of a cognitive something going on such that they're not really able to make a Section 9, but they still want to appoint somebody to be able to assist them. I make those Section 7, I would say, maybe once every couple of years. Whereas a Section 9 representation agreement, that's something I'll make every week. So the Section 9, that's the other type of a representation agreement. And that one is the most common one we see. It's the most common one we make, and it's the most common representation agreement that most adults end up having. The Section 9 representation agreement can have a bit of a wider scope in terms of the power that it can give. And it's the one that most adults will end up having. So just a little bit about these representation agreements. So as I've alluded to earlier, you must be capable. You must, the reason we want to do these documents, and I suggest doing them early, even if you're a relatively young person or a person not facing any type of a disability or diagnosis, best to get them done because we never know what's going to happen to us. We never know. You know, people have it, right, where a medical condition hits overnight and suddenly they transition from capable to not capable in just a very short amount of time. And you never know when that's going to be you who that happens to. So doing these documents while you're capable is so important. The law has a little bit of help in the sense of the law will presume, right? The law's default position is everyone who's an adult is capable. That's not the end of it, but that is the assumption we go in with, is that adults in Canada are capable. And just because an adult has some decline in their mental capacity or has some changes, that doesn't mean they're incapable. They're presumed to be capable. But as I do often see in my work, if there has been a change in mental capacity or a change in health, sometimes people will then accuse and allege and say, oh, but no, too late, doesn't know what they're doing. That can happen. That's another reason to do your documents early. So to just avoid any arguments to say capable or not capable. Because the law would say, if you're capable, you can make it, but if you're incapable, the document is invalid. So I'll go through here. Again, I don't suggest you memorize this. You can if you want. But there are different tests of capacity to make these different documents. And that's on purpose. Because just because an adult has had a change or a decline in their mental capacity doesn't mean they're incapable of everything. It may be that they're incapable to do some things, but not all the things. And the different documents have different tests of capacity to take that into account. So for a Section 7 type of a representation agreement, the adult, an adult with cognitive impairment or change can still often make these. That adult just needs to know that they want to have somebody called the representative who they want to have in place to help them make for them decisions. And the adult has to be able to say, this is who I prefer, and can express feelings of approval or disapproval. I know I said earlier that I will take questions at the end, but sometimes I can see these questions coming through and it makes sense to me to just kind of address some of the topics I can see flowing through. And one of them is, who decides if somebody's capable or not? And the very short answer is, boy, is that a tricky question. Boy, is that a tricky question. You know, the law would presume all adults are capable. So that's the beginning point. After that, if you go to a lawyer or a notary to do these documents, it's up to that lawyer or a notary to do the appropriate questioning to determine that in that lawyer or that notary's mind that you are capable to make those documents. It is, in that sense, a legal decision. It's the lawyer, so if that's me, it's my decision to say, I've met with John Doe and I've asked him lots of questions and I've looked at stuff and I think he's capable to do this. It's my decision to do it. If I decide somebody is capable, I will witness their signature. If I decide, on my view, that person I don't think is capable, I would not witness their signature myself, and I would talk to the person about what's going on. Often I would say, today is not a day that I will witness this signature, but if we want to meet again and try again, we can do that. On a very rare occasion, I have said to people that I will not be able to witness their documents because in my view, they're not capable. It's not often that happens, but at times it can happen. There is some confusion out there about, is it a lawyer, is it a doctor? And often the result is coordination. So if I, as a lawyer, am meeting with somebody and I'm uncertain, I need more information in order that I can decide whether somebody is capable or not to do the document that they're looking at, I may seek extra information from a doctor. It is not required that I do that, but it's something that I might decide I need that extra information from a doctor so that I can make this determination on capacity. There are doctors out there, sometimes a GP will be willing to make an assessment to say, yes, I know John Doe. John Doe is my patient and I've assessed their capacity, and in my medical view, John is capable or not, whatever that may be. There are also expert doctors out there whose job it is to assess capacity and to work with people on that. And there are those people out there too. It is a little bit tricky, I'm finding, trickier, kind of year by year, a little bit more trickier. Some GPs, you'll find they don't want to do this because they'll find either they're not expert enough to do it, or they don't want to get themselves embroiled in a legal situation because they want to be helping their client, their patient, and not being involved in any type of an adversarial kind of legal thing. So sometimes it can be tricky to get a GP or your GP to do that assessment, but there are experts out there, geriatricians and others who can do that if it is ever needed. Like I said when I started that topic, it can be a long answer on who decides whether somebody is capable or not. So this was just the end of when I was talking about capacity to make a Section 7 representation agreement. So the agreement that says who can help me make or make for me my health care and medical care and personal care decisions. The adult needs to express preferences for who they would like to make those decisions. That the adult has to be aware that the representative will be able to make decisions that can affect them, and that the adult needs to know that they have a trusting relationship with that person they're going to appoint. So many people will be able to meet that test for a Section 7 representation agreement, even if they have had some cognitive change or cognitive impairment or decline. This is the other type of a representation agreement, that Section 9 one, which is the more common one we see. So for that document, the adult must be able to understand the nature and consequences of that document. That's kind of vague, isn't it? It is. What does that mean? It's a little bit uncertain what it means, but it does mean that the adult has to be able to know what the document says, to understand that they're appointing somebody to make decisions for them if that's needed, or help make decisions, that they trust the adult, and to understand what the document means and who will have various bits of power. I can answer another question I see flowing through here too, which is about do people usually appoint the same person as a representative as an attorney? Sometimes. It's not required. Sometimes, yes. Sometimes people will say, they'll have a look at their people in their life and they'll say, well, my daughter lives really close to me and she knows and helps me out with my health stuff, so I'm going to appoint that daughter as my healthcare representative. But my nephew, gosh, is he good at money and he's always helping me with that stuff and he's an accountant, I'll appoint him for the power of attorney. Sometimes they're different people, sometimes they're the same people. Sometimes two people make the choice of maybe they'll have a family or a friend who they would like to help them make personal and healthcare decisions, but for their money, they think, I'd like a professional to do that. And they might appoint something like a trust company to act as their power of attorney. So if you have a bank in British Columbia, quite likely that bank also does these trust type services, and you could talk to them to say, hey, I'm thinking about making a power of attorney and I'd like a professional. Professionals are great. Trust companies are great. They do all of those things that they should do. They keep great records. They don't act in their own interest. They act for their clients. They're trustworthy. They're available. There are lots of good things. So that can be a choice too. And I'll just answer this question as well, because I've seen it flow through a few times, which is about, can it be one person, two people, five people? What about backups? You bet. All of those options are available. So, and there's pros and cons to that. You can appoint one person to be your representative. You can appoint 5 people. You can say, my primary person is this, but if they're not available, or, so one of the questions, if they're ever incapable, then I appoint this person. And if that person isn't available or they're incapable, then I appoint this person. And the list could go on and on. You can do all of that. There's pros and cons to appointing more than one person. You know, sometimes it's good in the sense that you can have a bit of a check and balance if you have two people. You can think about things like, do I want those two people? Must they always act together? Or can they act separately? You know, if you have two people and you trust the two of them equally, you might want to say, well, you know what if one of them's away on a cruise? I want the other one just to be able to do everything and not have to do it always together. You might want to do that. You might want to say, no, I do trust them, but I really would feel better if there's two people and they've got to make their decisions together. That might be the choice. Sometimes it's tricky if you appoint 3 people and they always must be together when they make the decision. What if one of them's on a cruise? What if one of them is located far away? What if, you know, you can have troubles if you appoint too many people to just be practical in that decision making. Practicality is part of what we look at when we, as lawyers or a notary, would help you in thinking about your choices. And I can see a question there about what if people live not in the same province or the same country? It's more ideal if you appoint somebody who is in British Columbia. They're local, they'll be able to come in and help, and we don't have any tax problems. But that's not everybody's family, and you can appoint anybody no matter where they are in the world. It might just be practically a little bit tricky for them to do their job and to help you, but it's possible. For some things, like for the will, when you're thinking of who is in charge of your will, you might want to take some advice about tax things before you appoint somebody who lives not in Canada. There can be some annoying little tax things. So on that one too, if you can appoint somebody in Canada, all the better. If it's just not possible in your situation, then it's possible that you can appoint somebody who's not Canadian. It's still possible. There might just be some tax stuff to be dealt with. I wanted to now talk about power of attorney. So this is, again, a document that applies while you're alive, and that you want somebody to help you make your decisions or to make decisions for you about your finances. That's what that power of attorney is. I put in here financial and legal decisions. That's true, right? Your power of attorney, if you appoint somebody, they can help you make decisions or can make decisions on your behalf about your legal affairs. Sometimes, just for simplicity's sake, I talk about it as who can make decisions about your money, but also they can make decisions about your legal affairs if that comes up. I just talk about money just to make it easier to understand. So that power of attorney could pay your bills, they could make decisions about your investments, they could sell real estate, they could buy real estate. That power of attorney document is a very powerful document. You can set out in the document when the document starts to be. Is it now? Is it available to be used now from the moment I sign it? And I'll tell you that's almost all power of attorneys are that way. They're valid the moment they're signed. But you can, if you want, say it's only applicable later. Only after this happens can this power of attorney be brought into force. I usually recommend to people that they don't do it that way unless they're very, very, very clear about when that trigger point is. And if you work with a lawyer or notary, they'll work with you on that. You can think about things like if somebody has to act as your power of attorney, should they be paid for that? It's real work. They have to keep your finances really well, and you want them to do that job well. And do you want them to get some reimbursement for that or no? You can choose about that, though that is all over the map in terms of what people do. And you can talk about different extent of authority. If you wanted, you could say, my power of attorney just for this one bank account, just for that bank account is this person, or just for my real estate. Or you can say, just overall, this is the person who can make decisions or help me make decisions. Almost all of what I see is that people just give the wide authority. They say about anything to do with my money or my finances or legal stuff. They put it all in. Very, very few people try and pick out a bit. I saw one of the questions fly through there about banks and their own POA forms, and you've absolutely hit on an issue. So these power of attorney documents, a lot of people will go to a lawyer or a notary to make up a power of attorney document, and that document should be accepted by the banks and the credit unions. It is valid over those accounts. Banks, I don't know how much they're doing it these days. Some of them may, but sometimes a bank will say, we want our own power of attorney form signed. We like that. And that is that bank's preference. Is it required? Maybe not, would be my view. Sorry, I needed to grab a sip of water. The power of attorney made through a lawyer or notary should be valid to impact any of those bank accounts. A bank may prefer it, and if you'd like to go through the bank's POA and use that, you can do that. But just know if you've done a bank power of attorney, it's probably only applicable to the specific bank and a specific account. It's not general. It doesn't go over everything. But that definitely, I've seen that cause some confusion for people. So similar to a representation agreement, the law would say all adults in Canada, we are assuming, we're presuming that they are capable. You don't have to prove you're capable, you are presumed to be capable. And how you communicate, that's not how we decide if you're capable or not. Some people, I've worked with people before who have a particular medical condition called aphasia. And sometimes people with aphasia, they might struggle to get a certain word out, or they may misuse a word because that's their medical condition. And just because of that's the way they communicate, that doesn't mean they're incapable. But it does cause a bit of extra work on the lawyer or the notary to really work hard to make sure, oh, that's the aphasia. Oh yeah, now I understand how this is going. Similar to a representative, an attorney, under a power of attorney document, they've got duties too. And I flag this for you to say, when you're thinking of your attorney, think about what person or persons who could do this work and make sure they could do these and comply or do these duties. So they must act honestly, they must act in good faith, they must use care and skill. They can't go beyond whatever the document says. If the document says this is only for this bank account, only the bank account. If it says it's general, then it's general. The attorney's got to keep records, and they've always got to act in the best interests of whoever made that power of attorney document. This is the slide about capacity to make a power of attorney document. Sometimes you'll hear it described that the capacity to make a power of attorney is higher than a representation agreement. And maybe that's true. But to make a power of attorney, you've got to understand your property. What do you got is sometimes how I say it, which is what do you own and what's it worth? When you go to your lawyer or notary to make a power of attorney, you will get 2 thumbs up from them if you show up with your financial documents right in your hand. So your printouts from your bank account statements, if you own any real estate, your latest property assessment showing the assessed value, if you own whatever it is, some companies, some shares, bring those financial documents so that you can say, oh, here's what I have and here's what it's worth. They will really appreciate that. Because part of that lawyer or notary's job is to make sure you know what your property is and its approximate value. You don't need to know to the penny, but you do need to have an approximate value. The way I often describe this is, sometimes when I'm meeting with people, I'll ask them what do they have in the bank, and they'll say, oh yeah, I've got money in the bank, and I'll say, how much money? And it's not unusual. People say, oh, I'm not sure, it goes up and down. And then I'll say, Well, give me an estimate. Is it $10 you have in the bank? Is it $100 million you have in the bank? And a lot of people will laugh at that, and I am meaning for it to be a bit funny, and they'll say, oh, of course I don't have 100 million. Actually, I've got about 100,000 here, and I've got 200,000 there. I say, okay, that's what I'm after. Is what is it? I don't need to know, is it 100,000 or is it 102,000? But do come in prepared to give a range of what you have. So to make that power of attorney, you need to know the obligations. If you have any dependents who are depending on you, you have to know that you've got those obligations to them. You've got to know, importantly, that if you make a power of attorney document, that your attorney, whoever you appoint, can do anything you can do in relation to your financial affairs. So what's important about that, and I've seen a little bit through some of these questions about nightmare situations people have faced. And especially in the litigation, so the fighting type work that I do, I've seen lots of nightmares. These documents, this power of attorney is super powerful. So you want to be careful to make sure you appoint people who you trust. Because if you appoint someone who isn't trustworthy, they can use that power of attorney and they can take your stuff. They can sell your house. They can move money out of your bank. And of course, once you figure it out, you can sue them for that and say, hey, that was my house, that was my bank account, give it back. But boy, is that ever time consuming and expensive and quite a hassle. Better to try and appoint somebody who you trust so that that just doesn't happen. And if there's nobody in your life who you say is really, really trustworthy, which happens, think about a trust company. I saw a question there, is it just the banks or that do the trust companies? No, almost all the banks and even the credit unions are tied to or affiliated with a trust company. Royal Bank has RB Royal Trust, CIBC has CIBC Trust, BMO has BMO Trust. They've all got those trust companies, but also there's independent trust companies who aren't attached to a bank. So there's lots of options out there. So I'm on to number 4 here, what you must know you must know and understand in order to be capable to make a power of attorney. You've got to know that if you're making this power of attorney, and if your attorney doesn't act properly, then the value of what you have might decline. If they make bad decisions for you, you're stuck with the outcome. You have to know that your attorney might misuse that authority. That is possible. You don't need to do anything about that. You just need to know that it's possible. And you also need to know that you can revoke that power of attorney at any point as long as you are capable. If you've made a power of attorney and then become incapable, you can't revoke that power of attorney. Part of what I said there is sort of scary, right? That you can sign this document as a power of attorney and then later somebody can sell your house and you didn't know it, and they can take money from your bank, and you might think, well, why in the world would anybody do that? The answer is that many, in fact, almost most people do this because it's good planning, because they have people in their life who are trustworthy and they are not worried about their stuff being stolen. Many, even most people would fall into that category, that they want to do this because they know, hey, something could happen to me. And I want to know that I've set things up so that somebody can come in and take over for me, and there'll be no lag time, and it will be easy and convenient. So even though there are risks, right, that somebody could use that and misuse it and steal your stuff, most people decide, actually, I've got some trustworthy people or a trustworthy trust company, and so they go ahead with it. Just to answer a couple of the questions I saw there, which is usually in a power of attorney document, it's common that we will say, I appoint so-and-so to be my attorney, but if they ever become incapable or they can't, or they're not around to do the job, then I appoint so-and-so. And if so-and-so ever becomes incapable or they can't do the job, then I appoint so-and-so as a backup. So that is right. If somebody is not capable anymore, they cannot act as an attorney. And so hopefully your document has a backup plan there to say, yeah, things happen. People pass away unexpectedly. If somebody's your attorney and they pass away, you may have a backup plan in there. And we usually try and do it not as separate documents, but in one document to put out the backups, to say my attorney is so-and-so. But if so-and-so is dead or incapable or not able to do it, then it's so-and-so. And if it's so-and-so, but they're dead or incapable, then it's so-and-so, so that the backup plan is all laid out there in that one document. How do you revoke a POA? You sign a piece of paper that says, I revoke that POA, and you give whoever is your attorney a copy of that piece of paper saying, I revoke that POA. That's the steps to do it. I was going to flip on to talking about the will here, but just in this moment, I'll just answer a few more of those power of attorney questions. And there was one that I saw here that I wanted to answer. There it is. Does whoever you appoint, so your attorney, do they need to sign the document at the same time? They do not. In fact, I recommend when I work with people that that attorney doesn't sign it, that in fact they sign it sometime later. So my advice is usually have the document prepared, the adult will sign it, and whoever they appoint, if that person ever does need to act as the attorney, they can just sign it then. And once they sign it at that later time, then they're off to the races. They don't need to be there at the same time. Sometimes people like for their attorney to sign it at the same time, and that's fine too. And I think part of why some people like that is because they want to know that the person they're appointing knows that they're being appointed and will accept the job. And that makes sense. You are not required to have that person with you and saying, yes, I'll accept the job. But it makes sense to say to that person, hey, if I did this, would you be okay with doing that for me? Because if the person said no, if you appointed me, I would just decline. I wouldn't even do it. Well, then why are you appointing them? So I think that's partly why sometimes people like to have their attorney there with them, so that we know, okay, yeah, everybody's on board with this. And also if that person as the attorney has any questions for the lawyer or notary, they can be asked right there.
Emily, it's Lori.
Yeah.
Just a couple more questions that I can see kind of
Okay.
about POA. One is, how do you revoke a POA? And another is, does the signature of the attorney need to be witnessed?
Okay, so you revoke a power of attorney just by signing a piece of paper saying, I revoke my power of attorney. And then you give that signed revocation document to your attorneys. That does the trick, and you must be capable to do that. To be capable to revoke a power of attorney is the same test as being capable to make a power of attorney. And the other one is, does that attorney's signature have to be witnessed? Kind of. How's that for an answer? Part of it is this: if your attorney wants to use the POA in order to deal with real estate, then yes, the attorney's signature needs to be witnessed by a lawyer or a notary. There's a thing that needs to be signed. But if it's not for real estate, then usually the attorney does not need that, although most people want it witnessed just because it's a helpful thing to have, and then there's no question about it. Sometimes sometimes I'll recommend sort of overkill, because why not? Because it'd be pretty annoying to be thinking that you've done a good job and made your power of attorney, and then someday later down the road, a bank or somebody has troubles. Oh, but the attorney's signature wasn't witnessed. And even though maybe it's not technically required, it's easier to just do it, have a witness, and then you know that it's going to be fine. So that was my maybe, probably type answer. This is the happy topic of what happens after we die. I was happy to talk about that. But it's reality. We're all going to die. A will is a piece of paper. It lets you set out what's going to happen after you die. And there's two main components of a will. Who's in charge? Who's in charge? You're going to be dead. So who's going to be able to go to the bank? Who's going to be able to deal with your real estate? Who's going to be able to take your favorite watch? Who's going to be in charge of whatever that was yours? That's your executor. You can have one executor. You can have 17 executors. You can have a person. You can have a trust company. You can have a combo of a person and a trust company. A lawyer or notary will really help you weigh out your particular options. But that's that role of an executor. And then the second main component of any will is who's going to get your stuff. A lot of people ask me about like very specific assets, and they'll say, well, I don't even know I'm going to change banks. I'm going to change banks. I don't want to do my will now because how will that even work? Most wills don't go through bank account by bank account or item by item and say this bank account to that person or this item to that person. You can do that. And people often do that with things like jewelry. I want this set of earrings to go to this niece, and I want these clothes to go to that daughter, or whatever the case may be. But with like specific, financial assets, I usually recommend to people to be more broad, because you never know. What if your bank account number changes? You decide to not go to the CIBC anymore because you've moved across town and the Royal Bank is across the street. Well, now do you have to change your will? Do you even remember to change your will because you've changed banks or bank account numbers? The much, much more common thing is that people do it in one of two ways. Most people say, here's who gets everything. Or they'll say something like, take everything that there is, everything I have, my money, my real estate, my everything that there is, and give 50% of it to so-and-so and 30% of it to so-and-so and the remainder to so-and-so, a person or a charity, whatever the case may be. That's the most common way. Another way people will do it, as opposed to saying this bank account to that person and this specific bank account to that person, people will say things like, I want to give $50,000 to each of my grandchildren for their education or whatever it may be. And the balance, I want you to divide it up equally between my children. That's a very common thing that we see. So maybe a specific amount, or you might say, I want $10,000 to my nice neighbor so-and-so who's really helped me out, and the rest equally between my children. Those are very possible things and common things to do. So capacity, that old problem. The test, you have to meet the test. You have to know what's going on in order to make a will, and your lawyer or a notary would be the one who makes sure you know what's going on. And these are the things you must know. You must know that making a will, the will only comes into speaking, if you will, when you die. Before you die, the will isn't doing anything because you're not dead. The thing that a will does is distributes property and says who's in charge after your death. So you must realize that a will only starts to speak after you're dead. You have to know what your stuff is. Similar to a POA, you have to know in a big picture way what's your stuff and what it's worth. I own a house and it's worth whatever it may be. People get, concerned that they don't know exactly. You don't need to know exactly. It's usually sufficient to say, I got a house, this is where it's located, the assessment was this amount, but I've got that mortgage of $300. That's excellent, right? Real estate goes up and down in value. Of course, we get that, but we want you to know what it is, where is it, and what is it generally worth. Same with the bank accounts. You don't need to tell me to the penny, but give me a sense of, well, at the CIBC, I've got an RSP and I've got an investment account. And if you took them all together, it'd be worth $100,000. or whatever it may be. You need to know that, and having the pieces of paper with you when you go to your notary or lawyer is going to make that process really easy. Often a notary or lawyer will send you what might be called a questionnaire or an information sheet, saying they want you to tell them in advance what's your stuff and what's it worth, because they want to get a sense of that so they can give you a good idea about your plan. You need to know, in order to be capable to make a will, who is expecting to inherit from you. So that means things like if you have a spouse or if you have children, they might be expecting to inherit from you. They would have entitlement at law. If you don't make a will, and you need to know who those people are. Effectively, who's your family? Who's your spouse? Who's your kids? Anybody other than that. And you need to know what your will does. You need to know, I'm giving $10,000 to my neighbor Sally, and I'm giving the rest between my children Tim and Todd and Tammy. Whatever the case may be, you need to be able to say that back in your own words. So even people who have some cognitive impairment, who have some cognitive change, they're often still able to make a will. Just because you have a diagnosis, just because you have something going on, doesn't mean you're not able, but do it early. You know, it's those fights. I do lots of these fights about, is somebody capable to make a will? And boy, are they time consuming and nasty, expensive bits of life, and trying to avoid that by doing your will early, just to avoid any worries about that. As with the other documents, you're presumed, the law says, yeah, if you're an adult, you're capable. And just because you've had some change or decline doesn't mean you're incapable. And just because you've had past mental health issues, that doesn't mean you're incapable either. You just need to meet the test on my previous slide, and then you're capable to make a will. Again, it's usually the lawyer or the notary who makes that decision. Sometimes they will get input from a doctor. Sometimes they might want to get input from 2 doctors, but the lawyer and the notary would usually be the one to determine that test if you go to see them. So this is the scary part. This is where I'm going to scare you into trying to inspire you to do these documents. So if you don't make a representation agreement, there is a backup plan, which is a good thing. So the law would say, if you don't make a representation agreement, here's the people who will make your healthcare, personal care decisions for you. And there's a list. If you don't have a document, but you have a spouse, it's the spouse. If you don't have a document and you have 2 spouses, which is possible, it's both of them together. So even better is if you make a document and you pick which one you want. If you don't have a representation agreement and you don't have a spouse, then it's your children, all your children together. And if you don't have a spouse and you don't have a children, then it's your parent. And if you don't have any of those, then it's your brother, sister. And if you don't have any of those, then it's your grandparent, and down the chain. So there is a backup plan in there, but it's not ideal in this way. If something happens to you, especially in an emergency way, the healthcare facility needs to figure out who can make the decisions. And if it's an emergency setting, you don't want them having to run around to try and figure out, okay, do you have a spouse? How am I going to figure that out? Do you have more than one spouse? Do you have a child? Who are those children? Where are they? How do I find them? What's their phone number? Oh, you don't, who's your parent? Boy, that's a lot of extra work, and it can be complicated for the healthcare facility to try and figure that out. Much better to just do your own documents that sets out everybody's name and phone number and all that stuff. So similarly, if you don't have a will, the fancy legal word is that you would die intestate, meaning you just don't have a will when you die. Then the law also says, oh, you died and you didn't have a will. Here's who gets your stuff. So if you have a spouse and no dependents, the spouse gets everything. If you have a spouse and some descendants or some children, then it gets mixed up sort of in between them. The law tells you kind of who gets what. If there's a spouse and dependents, the spouse gets a preferential share, and then it's divided amongst the spouse and the children. And there's kind of gets a bit complicated whether those children are shared between your spouse or not, it results in the outcome. And if you don't have any of those, then to your parents, and if you don't have any of those, to your siblings, and the list goes on and on. So there is a backup plan if you don't have a will in the law, but even better to have a will, because you might not like the backup plan that the law says, want something different, A, and B, the law might change. And you might like the list right now, but the law could change at any time, and you might not like the new law. So that would apply to you. The other bad potential outcome, and bad in the sense of it's time consuming and expensive, is if you don't have any of those documents and the backup plan isn't working there, then the court can step in. Yeah, the court can step in and make a decision about who is going to be responsible for your healthcare decisions or your financial decisions. And that's by the type of a legal proceeding called a committeeship. And the court can have that power. The court can have the power to determine capacity. And courts make those decisions all the time. And I, as a habit, read every new case in BC as they come out every day of the week. So I'm quite up to speed on the law. And I have noticed as years go by that I see more and more decisions being made where the court is being asked to make these decisions. And it's too bad in the sense that it's time consuming and expensive. And I often feel bad for the families of the people who have to be involved, because I know how stressful and time consuming and expensive that can be. And if you can prevent it by doing a document, boy, is that better. I think I sort of went over some of those disadvantages of having to go through that committee application. And those personal planning documents, we really recommend them. Right, you've heard it from me. I'm a bit of a salesperson here in terms of those documents, because I've seen the bad things when you don't do them. It does help people increase their autonomy, their own dignity. They're making their choices. That's a powerful thing to do. It absolutely saves money. Often people don't do these documents because they think the expense is too much. That's very common, and that. I understand that, right? It is expensive often to do these documents, but boy, does the upfront cost is so small in comparison to the potential cost of if you don't do the documents and then people have to deal with things later, boy, does that get very expensive. So the upfront cost is almost always significantly cheaper than if you don't do them. And that peace of mind, knowing that your wishes are going to be respected. There was Here, this is almost my last slide, so we're almost there to wrap up. But I did skip over one thing, which is I talked about how if you don't have the representation agreement, there's a backup plan in the law about who gets to make your personal healthcare decisions. And if you don't have a will, there's a backup plan in the law that, it goes to your spouse or your kids or your parents or whatever it may be. But in terms of your financial decisions, so if you're alive, but you're not capable to make your own decisions, if you have a power of attorney, boom, that power of attorney gets to step in and make those decisions for you, and that's good. But if you didn't make that power of attorney, there is no backup plan in the law. There's just none, and the only option would be to go through that committeeship. And that can be an expensive, time-consuming process. And there's absolutely going to be delay because the court needs to become involved. So that it won't just be, oh, shoot, right? Yesterday you got hit by that bus and now you're in a coma, but today I can go and help make sure your mortgage is paid and whatever it may be. Those committeeship, there'll always be some delay and so some challenges in administering the finances in that sense. This last slide I had here was just about how to prepare for trying to go see a lawyer or a notary. And I've given you some tips as we've gone through, but just to summarize those, think about what you want. And really importantly, think about who you trust. Think about who you trust and think about who you'd want to be in charge. Who would you want to be in charge of your personal health care? Who'd you want to be in charge of your finances? After it's all over and you're dead, who should be in charge and who should get your stuff? Think about it in advance. That really helps. Of course, ask questions. Bring your notes, making sure that you're prepared to ask those questions that you want. You know, sometimes people find going to their lawyer or notary can be a bit intimidating, or they're a bit nervous, and then they'll forget to ask their questions. And that's common. I've certainly suffered from that myself. You forget, right? Because of the whole hype of the whole situation. Bring your notes so you know that you're going to remember to check your notes. Take your time. Take your time. It's not a race to get things done. So make sure you understand what's going on and are comfortable with the process. And if it's applicable to you, make sure you're choosing a time and a place that you are comfortable with. Some people are better in the morning. Some people are better in the afternoon. Whatever that may be, just make a decision that best makes it so that you're able to show up and be clear in your thinking at the time that you're meeting with whoever that may be. And I've said throughout here, another tip is, and it helps you to try and reduce the overall expenses, come prepared with your documents. You know, have an outline of your finances and have your bank account statements and your real estate stuff with you. It just makes it all a lot simpler. And if you make it simpler for your lawyer or your notary, it's usually less expensive, which is a good thing. And just as the last sort of a resource, if you are or know somebody who is an older adult who is doesn't have a lot of extra financial means but wants to do these documents, Access Pro Bono is an organization in BC who can provide some free legal assistance to prepare these personal planning documents to low-income seniors in BC. It's not ideal because the wait list can be quite long. It can take quite a while to get an appointment, but if you really don't, you or whoever it is that you're trying to help really doesn't have the finances to try and get this done themselves, that's a possible resource for you to try and access. So that was the end of my slides, and that's me, and that was a picture of me from just a couple of weeks ago. I got a new picture, and that's my contact information there. If you had any other questions, you could reach out to me.
One question that came up from a participant a few times, have you heard of something called a digital closure kit? And I think he's referencing something that allows you to capture like all of your online passwords and that kinds of things. And can you speak to that at all?
Yeah, I can speak to that. And I also had flagged to myself, but then I forgot to make a note. So I forgot that I wanted to talk about the most just a little bit as well. So I'll do those two things and I'll actually make a note. So one of the things these days that people do think about in terms of their estate is who's going to deal with all my digital stuff? And you can ask your lawyer or notary about that if you have much of value that is like a digital asset. It's tricky, right? These online providers, they might be located anywhere in the world. And if they're located in BC or Canada, it's pretty easy just using a will to say, hey, I'm the executor. This person is dead. Here's their death certificate. Can I please go get access to their digital file? And that won't be too tricky. But you know, there's providers all around the world, and, you know, best of luck in dealing with those. So some people do what that person was mentioning, which is trying to set up a way using some company or some way that if they do pass away or become incapable, somebody has access to their passwords. It is easier to have those passwords, but people, it all sort of works out eventually in the sense that when someone does pass away, if you don't have the passwords, you know, we go through the various companies and we figure out what those passwords may be. But it is something to think about. Your email, whatever it is that you have online, has lots of information. Lots of it. How is somebody possibly going to access it? If you're not capable anymore, or if you've passed away, you can think about that and try and set up an appropriate plan, which that sounds like that is a company or a service that's being offered that they can do that.
Great, thank you.
Yeah, the real trick comes with digital assets, actual digital assets like Bitcoin or something, which doesn't have a physical existence in the world. If you've got assets like that, talk to a lawyer probably, and they'll try and help you to set up how you get those actual digital assets passed on the way you want. That can be quite tricky. I wanted to touch on, because I'd seen a question in there about the most. So that's a health-related document that tries to set out what you might want or not want in terms of your health and your healthcare decisions, because things can happen. So the most, in my view, sorry, I'm just going to stop my screen share there. There we go. The most doesn't replace a representation agreement. They often act together, right? Because what the representation agreement does is say, this is the person or the people who can make or help me make my medical or healthcare decisions. It doesn't tell them, and these are the decisions I want you to make. It possibly could, but very rarely. It says, this is the person or the persons. And then how are they going to make the decisions? Well, hopefully you've talked with them. Hopefully you've communicated with them and said, these are my values. If this kind of thing ever happens to me, this is kind of the person I am and what I would like to happen. What the most does is, through the healthcare institution or the hospital or a care facility or whatever it may be, it allows some more specific direction to say, this is the kind of thing I'd want, and this is the kind of thing I wouldn't want. So it's talking about the actual treatment versus the person or persons who make the decisions about it. So I think for many people, you'll end up having both, right? But I just worry about people who think, well, I've done the most, therefore I don't need to do a representation agreement. And my advice is always do a representation agreement. And I recommend a representation agreement for young and old people. And the big reason is this: when you go, we don't know what's going to happen to our health. Young people end up in healthcare facilities or care facilities or what have you, right? Often the administrative staff of a healthcare facility, let alone a hospital or other health facility, they want to see that representation agreement. They've been trained on representation agreements. They know what a representation agreement is. Their own internal documents say, get the representation agreement. So I cannot stress strongly enough, get a representation agreement, because those are stressful moments. You know, you are having to go to a healthcare institution or a care facility or a hospital. You're stressed out, your family members are stressed out, and then the person says, well, where's your representation agreement? And everyone's in a big flap. It's stressful as all heck. Just do it in advance. It's always worth the cost. You will save time and stress and administrative hassle by doing it in advance. So I did want to say that.
Yeah, thank you very much for bringing that up. One of the things that I wanted to share was a comment from someone who said, I've recently received an Alzheimer's diagnosis. This is part of helping us think about next steps. And so just really expressing appreciation. There's lots of that I'm sure you've seen come through. Further to it, a question that says, as a person who's received a diagnosis, how can I place my investments at arm's length from me or transfer them to my beneficiary so that they are not used in paying for his living and care needs? And I think that comes, and please jump in if you hear me say anything wrong, I think that he is referring to if he needs long-term care or care from the government services. There is a difference. Any healthcare services provided by the government, whether it's long-term care, assisted living, that is based on your income, not your assets. And so that would be, that shouldn't your assets shouldn't impact the amount that the government assesses to you. We do have a session coming up next week called Accessing Services that will address some of that more fully. So you can call the First Link Dementia Helpline to talk about your particular situation, and also tune in next week. And Emily, I don't know if you have more to say on that, or.
Yeah, it's a pretty tricky topic.
Yeah.
That's what I would say. And I think you do well to contact a lawyer about that particular situation. There are some options, but there are really things to think about in terms of that. And you want to be cautious if you're going to transfer your things away. Then you've transferred your things away and you want to have your things. And if your health or whatever it is doesn't go according to the plan, you think now you've given away your things and you might not ever get them back. And it can be a bit risky to do that. So there's a lot of thought that could go into that. So I would say, there are advisors out there who can help you on that, but be thoughtful about that and prudent about that. There are lots of tools, if you will, out there that I haven't really talked upon because they're a bit more complex and they're definitely not going to apply to everyone. Things like there's a complicated thing out there called an alter ego trust. It's out there. Lots of people over 65 in Canada do it. It's complicated, and talk to your lawyer and they'll tell you all about it. But it's not applicable to all or most people. But, the overall advice I try to give in these sessions, is those 3 documents I talked about: the representation agreement, the power of attorney, the will. I think everyone should have those. Young, old, whatever culture, however rich or poor, everyone I think should have those 3 documents. If you have something beyond that, maybe, and it's more specific to a particular situation, but I think everyone should have those 3. That's why I talk about those 3.
As do we. So
Yeah.
Thank you very much for that. Yeah. Someone says they agree that many people are best to rely on professional advisors, and certainly the society, the Alzheimer's Society, that's what we recommend as well. This person says you can do it yourself. He did and had a lawyer witness. He says, will you please mention that there are some excellent guides on the internet? I believe BC Palliative Care Association has one, and there are good government of BC sites. Just wondering what your thoughts are.
Yeah, so there are lots of resources online about that, and I'll just give my candid thoughts on that. Sometimes those resources are far more technical and confusing than they need be, and people will end up going into a rabbit hole of much more detail and confusion than if they hired a professional to walk them through the process, right? So that's a reason I say just talk to your lawyer or notary. They'll just tell you what it is and you'll get right to the answer. If there's ever going to be a dispute about your documents, it is more likely, I would say, that your documents will be upheld if you had a lawyer or a notary do it than if you did it yourself. All that being said, yes, you can do, in particular, the representation agreement yourself. There are some forms you can find online. You can do it up, sign it in front of 2 witnesses who are not your representatives or paid caregivers, and that will be valid. There are tricks. A lot of people who do the documents themselves, they can make a mistake on that, but people can do it well. But sometimes things happen like this, even though it's been done. It's proper, everything done just perfectly. Sometimes the document will be rejected by a bank, by a care facility, because they're more used to seeing a lawyer or a notary signature there. Now, my view is those documents are legally binding. They are valid. But if you can't get your bank, you can't get your care facility to act upon them, what good is it to have the fight, which I can tell you I've had many times, to say, no, but it's legally binding. And they say, oh, but internally we don't accept it. And then you're in a loop. So, yes, it is possible, especially with the representation to do it yourself, but there's some risks. With the power of attorney, again, it can be done by yourself. There's online resources about that. But if you want that power of attorney to be used for real estate in British Columbia, that is a real big trick. Hard to make those be used for real estate in British Columbia. There's sort of some legal requirements that says that for real estate, the POA must be witnessed by a lawyer or a notary. And then the same with a will. Some people do their wills themselves. There's online guides and resources about that. I've been involved in far too many lawsuits where somebody did a will themselves and they thought they did it well, but little did they know, because of various technicalities in the law, that there's a mistake of this or there's an ambiguity in this, and then we end up spending a heck of a lot of time and money trying to sort it out. So those are sort of warnings. But to that person's comment, yes, sometimes people do it themselves and it works out fine. That can be. It's just that also there can be some downside to that too.
Last thing, Emily, in the last minute, this came up. Where should the original documents be kept? Yeah, and not just the ones here, but advanced care documents, and who should be informed.
Yeah, I deal with this all the time with, people who meet with me. And this is what I say. If you have a spot at home, that's a safe spot that you can get into, or your representative can get into, that's hopefully fireproof and waterproof, that can be convenient. You can get those little safes at whatever, Canadian Tire, usually for $100. Just make sure you know how to get into the thing. That can be appropriate, especially for healthcare documents, because you might have a healthcare emergency at 1 o'clock in the morning. And if you left your healthcare documents at a lawyer's office or at a bank safety deposit box, good luck at 1 in the morning on a Saturday getting your documents. So often I recommend for the healthcare ones, people keep them at home in a really safe place. If people totally trust their representative or their attorney, which hopefully they do, I often make multiple originals and I say, give them to your people. If you're totally trusting of your person, give them an original. So if it's 1 in the morning on Saturday night, they've got the documents in their hand, and make sure they also try and keep them in a waterproof, fireproof place. Sometimes as the lawyer, I also hang on to documents. I have a massive, I don't personally own it, but my work does have a massive safe that's waterproof and fireproof, and lots of lawyers do have that. You can do the bank safety deposit box. There's concerns, and often people put a will there. The problem with that is, what happens when you lose the key? That's a problem. And the other problem is, if you put your power of attorney and stuff inside the safety deposit box, and now you're incapable, no one can get in the safety deposit box to get the document out. It's a bit of a rub. And what if it's 1 a.m. on Saturday night and you need it? It can be stuck in there, and you might not get it as quickly as you want. So for some documents, it is appropriate to go in that bank safe, but sometimes there's other solutions that are just a little bit more practical or tangible or something like that.
Emily, we could go on. We often get lots of questions. I have rarely seen the chat box, excuse me, flow as robustly as it did today. And so I greatly, greatly appreciate your time. The thanks for your presentation are flowing into the chat box. Thank you very, very much for your generosity, your expertise, and your compassion in this regard. So thank you, and thank you everyone for participating today. Please feel free to call the First Link Dementia Helpline if you have questions.
Thanks for the opportunity. I was happy to present, Laura. Thanks for everyone for showing up and your questions and interest in this.
Thanks a lot. Bye-bye, everyone.